A rent repayment order is an order for the repayment of rent. It's made by a first-tier tribunal and requires a landlord or agent to repay rent where they have committed a relevant offence in respect of a tenancy or licence agreement. The relevant offences are using or threatening to use violence to secure entry to the let premises, unlawful eviction or harassment, the failure to comply with an improvement notice or prohibition order, and the failure to obtain a HMO licence or selective licence. An application for a rent repayment order can be made by a local authority or by a tenant. In either case, the amount of rent to be repaid cannot exceed 12 months worth of rent. Where the application is made by a local authority, the amount of rent to be repaid cannot exceed the amount of universal credit or housing benefit paid during the relevant period. Where the application is made by a tenant, the amount of rent to be repaid cannot exceed the amount of rent paid by the tenant, and the tribunal must deduct any housing benefit or universal credit paid from the amount of rent to be repaid to the tenant. This application must be made within 12 months of the alleged offence having been committed, otherwise the application must fail. The burden of proof is upon the applicant to prove to the tribunal the alleged offence has been committed. The standard of proof in the tribunal for rent repayment orders is the criminal standard of proof. That is to say that the tribunal must be satisfied beyond any reasonable doubt that the alleged offence has been committed in order for it to make a rent repayment order. The amount of rent to be repaid is essentially at the discretion of the tribunal. Some of the factors the tribunal must consider are set out in the Housing and Planning Act 2016, and they are the conduct of the landlord, the conduct of the tenant, the financial circumstances of the landlord, and whether or not the landlord has already been convicted in a criminal court of the same alleged offence or received a financial penalty from the local authority for the same alleged offence. It should be noted that if a landlord or agent has been convicted of the same alleged offence or received a financial penalty for the same alleged offence, a rent repayment order can still be made, even if it relates to the same offence. If you have received an application for a rent repayment order, you should seek legal advice as soon as possible. There can be mitigating factors that can reduce your financial liability in the event a rent repayment order is likely to be made against you. In other cases, there can be complete defences to the application. You can contact our legal team if you've received an application for a rent repayment order, and we will be able to advise you on your matter and provide representation at the hearing.